Eleuterio owns a parcel of land in Lawag City. In January of 1971, he allowed Maria's family to construct a house and live on his property. In April 1971, he sold the land to Maria and executed a deed of absolute sale thereto, but the same was not registered by Maria before the Register of Deeds. When Eleuterio died last year, his son Ruben was his sole heir or survivor. Ruben wanted Maria and her family to leave the property. According to Ruben, his father sold the property to him in March 1971 and caused the transfer of title to his name in 1976, or 5 years after the alleged sale. According to Ruben, he has a clear right to evict Maria from the property because he is the registered owner. In her defense, Maria claimed that Ruben's title was fraudulent because Ruben knew that she was the one living in the said property for more than 30 years in the concept of owner. Ruben countered that he has a better right to possess the property because of his title. In a similar case decided by the Supreme Court, it was held that Ruben's father engaged in a double sale of the disputed property. The records of the case show that it took Ruben more or less 5 years, 1971 when he acquired the property from his father, to 1976 to register the conveyance and cause the issuance of the land title registered in his name under the torrent system. Maria, on the other hand, continued her possession of the property but without bothering to register them or to initiate any action to fortify her ownership. Remember that unlawful detainer is an action to recover possession of real property from one who illegally withholds possession after the expiration or termination of the right to hold possession under any contract, express or implied. The possession of the defendant in an unlawful detainer case is usually legal from the start but became illegal due to the expiration or termination of the right to possess. In the case of Cabrera versus Guetaruela, the court held that a complaint sufficiently alleges a cause of action for unlawful detainer if it recites the following. First, initially, possession of property by the defendant was by contract with or by tolerance of the plaintiff. Or second, eventually, such possession became illegal upon notice by plaintiff to defendant of the termination of the latter's right of possession. Third, the defendant remained in possession of the property and deprived the plaintiff of the enjoyment thereof. And fourth, within 1 year from the last demand of defendant to vacate the property, the plaintiff instituted the complaint for ejectment. Based on the above, it is obvious that Ruben has not complied with the requirements sufficient to warrant the success of his unlawful detainer complaint against Maria. Maria is entitled to a continued possession of the subject property since her possession has been established as one in the concept of ownership. It is settled in jurisprudence that a torrent certificate of title cannot be the subject of collateral attack. Such attacks, such as alleging that it is fraudulent, must be direct and not mere collateral. Considering that this is an unlawful detainer case wherein the sole issue to be decided is possession de facto rather than possession de jure, a collateral attack by Maria on Ruben's title is not allowed. The Supreme Court ruled that in the present case, they will only resolve the issue of who has the better right to possession in relation to the issue of disputed ownership of the subject property. Questions regarding the validity of Ruben's title can be ventilated in a proper suit instituted to directly attack its validity. It is an issue that cannot be resolved definitely in this case. Thank you for your growing trust with us here at People's Television. Please do not hesitate to email us at ptv4newscenter@gmail.com. This is Attorney JJ Jimeno Atienza for the Rule of Law.